Do you still maintain that this flirty interactions between you and the complainant, as you put it, was appropriate to occur in the workplace between the most senior person in that division and one of the most junior staff members?
Evidence leader, you have asked a question that has got various components. Let me find a way of answering this. Any judge, any person, anywhere for that matter, is behaving appropriately if they harass others. Then I'm talking about an inappropriate conduct. But when people flirt with one another and the flirtation is not unwanted, I do not believe that there is anything that one may say it should be frowned upon, because I'm going to ask you in terms of what?
You said now that you are neither an employer or an employee. So I want to put it to you that it is not about whether or not you are an employer, a manager, a supervisor, or anything. You are the judge president of that division.
Very
true. And she is a secretary?
Yes.
That works in courts?
Yes.
You are the most powerful person in that court.
What do you mean by powerful?
Don't you see yourself as the person with the most authority in that division?
Let me remind you, if we talk about the issue of power, it shifts, especially in the context of what we are talking about. So at an abstract level, let's start with what the first proposition you made. And I want to rectify something. Insofar as you sought to refer to the Labor Relations Act, it is to that extent that I said to you, I am not an employee, because the Labor Relations Act applies to employers and employees. So it is within that context that I answered the way I did. And then the second proposition about power and authority, yes and no. I'll tell you why I say yes and no. In this flirtatious relationship, I never invoked what you perceive as power on the facts of this interaction.
I'm not talking about the WhatsApp relationships. I'm talking about at the workplace, you are the most powerful person in that division. Is that correct?
Correct.
Thank you. In your evidence, you also said that many judges have had relationship with their secretaries. In fact, some of them have married their secretaries.
Could you please put it the way I did? All I was simply saying there are judges that have married their secretaries. They would have started somewhere, either flirtation or whatever else, and then it would have gravitated to them becoming a couple, married in the true sense. Please, if possible, save me from mentioning names.
I don't want you to mention names.
Thank you.
You testified about that.
Yes.
So we need to unpack this. We don't know what the circumstances was that surrounded
Yes.
relationships. This case is different than those.
How so? So you know there are. Is it the position that you know there are? Because I need to move from the premise that we are on par on that subject.
Are you now asking the questions to me?
Not necessarily asking questions. I am seeking clarity. Are we moving from the premise that you accept that it has previously happened?
This tribunal does not have any evidence before it about the circumstances of those relationships. Is that correct?
Evidence leader, it was merely a postulation in passing for me to mention that this thing that is looked upon as very taboo, for that matter, this is pure flirtation. You must remember that there are judges that have married their secretaries. That's all I was saying.
But
without suggesting that I know how they eventually got to be married. I have no idea.
I want to put it to you that this case is different because in this case, the complainant do not agree that there was consent. It was not a consensual relationship.
You keep on coming with a presumption, evidence leader, and I don't believe that is correct of you to do so. This notion that once sexual harassment is mentioned, then surely one must have committed it. This is an allegation. I am here to refute or rebut that allegation. So the fact that the complainant says, well, I want to lodge a complaint because as far as I'm concerned, the chats were unwanted, that is a matter for determination by the tribunal. That is why we are here. That is why the charge sheet has been couched the way it is.
Chair, if this is a convenient time, I see it's now only 5 o'clock, but I'm going to go into the specific WhatsApps, and it has been a long day. I don't know if you will give me the leniency to adjourn until tomorrow. We can start at 9, as suggested in Chambers earlier this morning, or earlier today. I foresee that we will be able to finish in the 2 days that we have left.
Excuse me. Let me make this point. We had indicated that we would sit until 6 o'clock because we need to finish the evidence in this case. And I insisted that we are going to proceed. The cross-examination must start today, and if need be, we are going to sit until 6 o'clock because we need to finish this case. I think the public and the nation are becoming weary of this case. Resources are being plowed into this case, and we don't want this case to be another Senzomiwa case or to be the Omotoso case, cases which won't run forever. It will not happen in these proceedings. If need be, we'll sit until 10 o'clock every single day in the evening. I'm reluctantly, very reluctantly, acceding to a request for us to stop now at 5:15 when we had said that we'll sit until 6 o'clock. I'm doing that very reluctantly. But let me be very clear. This is not going to be a never-ending process. If need be, from tomorrow we'll sit until 10 o'clock. We adjourn until tomorrow 9 o'clock.